ICE raid stopped by Federal Appeals Court. Welcome to Law and Society. Please subscribe. Today I'm going to talk briefly about the Los Angeles and the Central District of California case that was ruled on for a temporary restraining order by the district court judge in Central California. And the case was appealed. So the district court held that Donald Trump's government, that the federal government, was conducting stops in violation of the Fourth Amendment that requires, in cases of immigration, a standard of reasonable suspicion, which is a particularized, professionally trained eye looking at a particular set of facts and then coming to a conclusion based on the totality of the circumstances that there is illegal immigration happening at that place. Now, what the district court held was that the government could not carry out reasonable suspicion raids, and they violate the Constitution if all the government is basing its reasonable suspicion on are factors like ethnicity, which being Latino, language they speak, in this case being Spanish, where they work or where they gather as sole factors of reasonable suspicion. In fact, put them all together and that still doesn't rise to particularized reasonable suspicion. And the district court held that without the temporary restraining order in this particular district, there would be irreparable harm to people who are similarly situated in this district, in the district over which the Central District of California, where this is happening, which is geographically specific, and therefore stopped the federal government from conducting their ICE raids in violation of the district court order. It was appealed, and just 6 or so hours ago, the Ninth Circuit Court of Appeals ruled in upholding the district court's temporary restraining order with a small exception to it. So the appellate court said that no, the district court did not abuse its discretion and there was no clear error in administering the law and matching it up to the facts, that the district court properly ruled that not imposed, mind you, this is a temporary restraining order while there is a case that is pending. This is about the case that has been brought, and then a temporary restraining order has been asked so as to stop the federal government from conducting these illegal raids. And so in the District of California, there is now a stop put in by the Ninth Circuit, and the Ninth Circuit says no, the district court was right when it concluded that the government was violating the Fourth Amendment constitutional rights. And when you violate constitutional rights, that is enough injury to show irreparable harm. And the fact that there is a likelihood of irreparable harm, and in determining whether there would be, that they could put in the temporary restraining order, whether the plaintiffs would succeed on the merits, and in this case, the district court held that it would, and the appellate court doesn't go against that. So the appellate court essentially says that the defendants argue that plaintiffs cannot show a sufficient likelihood of future injury to support standing for injunctive relief. And in that case, the appellate court says, look, if you have this unconstitutional order in place in the Central District of California, then this practice, as it has been shown through the record of the plaintiffs, will subject people who fall into the categories of the plaintiffs or the or the association plaintiffs, like the different legal associations and farm associations that have joined the lawsuit, in saying that if you continue these raids, those illegal raids will continue in the Central District of California, and the same exact constitutional violations would take place. And that is enough to show that there's a likelihood of future injury. These defendants also say even if they can meet, even if the courts, plaintiffs meet the Article 3 threshold for standing, they still cannot show a real and immediate threat that they will be harmed again, sufficient to justify injunctive relief. But as the plaintiffs have shown, and the appellate court brings that up, that some of the plaintiffs were subjected to the same stop more than once. That the government has this policy of conducting these roving patrols that go on and do not have any particularized reasonable suspicion, and they go after people based on their color of their skin, where they work, where they're standing together, what language they speak, and nothing else. And then the defendants are claiming that as to the substance of the temporary restraining order, defendants say it is impermissibly vague, inconsistent with the Fourth Amendment, and exceeds what is necessary to provide plaintiffs complete relief. Well, in that regard, the appellate court says that the district court's order is right on all accounts, except for saying in the section that in connection with compliance of the Fourth Amendment, defendants may not rely solely upon those four factors that I said, color of skin, language you speak, presence at a particular location, or work that you do. They solely, alone, or in combination, to form reasonable suspicion for a tentative stop. So you cannot use those solely on those factors or in combination, except as permitted by law. So that part, except as permitted by law, is vague, is what the appellate court says. But it upholds the district court's order saying that you cannot have these raids. These raids violate the Fourth Amendment of the Constitution, and you are stopped from conducting these stops in this district unless there's reasonable suspicion, and you cannot use reasonable suspicion on the basis of the four factors mentioned in paragraph B. And with that said, the appellate court upholds the district court's ruling. It's a 61-page ruling. I am going to be leaving the reference in the description box of this video. I'm simply not going to go through the whole ruling with you because it is very similar to the argument set forth in the district court, and it is an affirmation of that ruling. With that said, thank you so much for listening. I'm happy that I've kept it below 10 minutes and gotten you the basic information. Please like, share, and subscribe, and I'll talk to you soon.